Hello students, topic for today's lecture is freedoms and the discretionary powers. What is the basically freedom that has been given to our constitution and what are the discretionary powers given to it? Under the terms of law, a discretionary authority is a law of the administrative authority that makes a certain act of two or more opportunities. In other words, its target is to choose a solution that has the best outcome. Then the discretionary law exists when the administration can choose between the different behaviors if it has been implementation of the law which meet the conditions. It has been given by H. Maurer in the year 1994 in the page number 126. The term discretionary authority means an authority with which the administrative authority entrusts certain degree of freedom in the terms of making a decision in order to choose one of the many legally administrative decisions that considers it to be appropriate. In a case of a discretionary decision, one should choose the alternative that best suits the public interest. That is when using a discretionary authority, officials must take into account the social interest. Moreover, their actions and the decisions must not exceed the arbitrariness. Discretionary acts must be brought within the authority and in accordance with the objective to be achieved by the authorization. The norm which contains discretionary authority, it is necessary to be determined the purpose precisely and unambiguously for which it allows administrative discretion. In some cases, the intention of the legislator is evident from the legislative instrument, but in the other case, the purpose of which is entrusted with the certain discretionary, which may not be obvious. Then it is advisable that when a certain discretionary authority is predicted, the objective's achievement is to point it out in the text of the law as clearly possible that entrusts that rating. When in the law that does not stand explicitly, then this power should be in the case be made in the public interest. The act passed based on the discretionary authority is obliged to state regulation and the reasons taken into account in its decisions, which means that the solution must be elaborated. Now we'll deal the procedure in discretionary making. The discretionary act should be taken by the competent authority in the prescribed procedure on the basis of established legally relevant or the true facts. So, the jurisdiction procedures for the adoption of the act and of the facts are elements that cannot be subject to the discretionary decisions. Administrative authority in the exercise of discretionary authority must not endeavor to achieve a different goal than that for which it is entrusted with the authority. Second, it should respect the principle of objectivity and impartiality, taking into account only the factors that are relevant in this case. Then, it should respect the principle of the equality before the law, avoiding unfair discrimination. Then, it need to maintain an appropriate balance between any adverse effect that its decision may have on the rights, freedom, and interest of the individuals. And the objective decision should realize that should provide a reasonable balance between the interests involved. For example, the public interest on the one hand and the private interest on the individuals on the other hand. Then it also helps to make a decision within reasonable time. Then it must exercise all the other general administrative guidelines in a consistent manner. I hope the topic must be clear to you. Thank you.